Order. The Assembly will consider the Youth Justice and Criminal Code Amendment Bill 2026 Serial 66. Would anyone like to indicate any particular clauses? Member for Bodger.
Thank you, Mr Deputy Speaker. Clause 2, 6, 8, 9, 10 and 13 and 19 and 18.
So I'll just repeat that. 2, 6, 8, 9, 10, 13, 18 and 19? Correct?
Yes.
Member for Johnson?
Yeah, I also have 7, 12 and I think the same ones as the member for Gloucester.
7 and 12 added to that list. Okay. Thank you very much. So we'll just proceed. Initially, okay. The question is that clause 1 stands printed. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. The question is that clause 2 stands printed. Member for Gloucester.
Thank you, Mr Deputy Speaker. Minister, could you confirm when the legislation is expected to commence or to be gazetted?
In September this year.
Sorry, September this year? Thank you.
Yeah, of course, the list administrator, but that's our plan.
Thank you. No further questions on clause 2.
No further questions? Okay. The question is that clause 2 stand as printed. Those that opinion say aye, the contrary no. I think the ayes have it. Is it the wish of the Assembly that clauses 3 to 5 be considered together?
Aye.
There being no objection, it is so ordered. The question is that clauses 3 to 5 stand as printed. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. The question is that clause 6 stand as printed. Member for Bodger.
Thank you, Mr Deputy Speaker. Minister, can you provide us with an example of what is meant by has knowledge in relation to an offence as set out in section 17A subsection 1C?
Yes, certainly. That will be a case by case based on the police investigations and the circumstances surrounding that particular event that the police are investigating.
Thank you. And Minister,
may have occurred.
Yeah. What type of information will be relied on as evidence?
Sorry,
so is that physical evidence or is it speculation, social media?
No, it's going to be whatever, it's a case by case, whatever the police do to be able to form a view, but they've got to form a reasonable set of circumstances,
right.
A reasonable view, and that's what the police do to investigate any crime. They've got to have a reasonable grounds. Yeah.
Thank you. And how will police record what evidence they're relying on in relation to 17A Part B, C?
A body cam.
Body cam?
And body cam and written notes as well.
Thank you. Minister, what provisions are in place to ensure that officers adequately comply with section 17A subsection 4, given the young people who interact with the justice system often have developmental and cognitive behavioural challenges, including unmet disability and health needs?
The police undergo a very difficult training program. They are experienced police officers, and if you have a fresh police officer, from my experience, they always have a senior police officer. So the answer is they'll rely upon their experience as police officers.
Thank you. And Minister, I acknowledge and understand that you're not the police minister, but do you have a list of available resources that are available to police which support effective, age-appropriate and trauma-informed communication about what happens during a protected interview?
That's an operational matter, but the police deal with criminals every day, and again, they do a great job. I clearly support the police, and I don't think you do.
Thank you. So, Minister, what training will be provided to officers on the appropriate use of 17B, which is the urgency threshold? What particular training will be provided on gaining informed consent from a child in these circumstances?
The exact same training now they get to become a police officer.
So there is no additional training, you're saying it's already happening?
It's an operational, but the police will change their operational and their standing orders to make sure that they comply with the legislation, as they do with all bits of legislation as they get changed.
Sure. And what evidence supports the inclusion of 17A subsection 6?
It came from a review from New South Wales, and the research indicates protected interviews protects young people from statements being used against them, hereby removing systemic barriers for diversion into programs. So it's about the diversion pathways.
Thank you. Minister, I understand the policy intent behind 17A is to enable referrals to diversion where appropriate. Are you able to explain how this will work if 17A protects children from having the information they provide used against them and the diversion programs typically requiring an admission or finding of guilt?
Yeah, the diversion program the legislation has been changed, clearly not across it, but you don't need a finding of guilt. It's about just going through to try and divert to stop that further offending.
So, Minister, can you confirm that 17B means it will be possible for any child to be questioned with police without their parents' knowledge?
Correct.
That's correct? So, Minister, why was a provision like 17A subsection 6 not included in 17B?
Because this is on the moment, and it can happen.
Sorry,
I
just couldn't hear you the first part.
This is in the moment. This is like I said in my wrapping up. This is about trying to give the police some information they need to stop that weapon or that vehicle being used, just to help the young offenders not hurt themselves. So the police may find someone on the side of the road, they'll conduct an interview, recorded by the body cam and take the notes, and they'll say, yeah, that Hilux is around the corner 2 blocks down. Police can go around there and stop that offending right there, nip it in the butt to make sure that the community and also the young offenders don't hurt themselves as we move forward.
Thank you. Minister, what evidence has informed the drafting of 17B?
There was a research done in New South Wales and in Queensland.
What was that? Sorry, I didn't hear that first part. Research was done in New South Wales and Queensland.
Yeah.
And how will these amendments be communicated, Minister, especially to people in remote areas?
That'll be part of the communication strategy undertaken by the police and also corrections and the government in general, because this is about trying to keep the community safe, and there will be a whole range of work done, but it will really be based on the police and corrections communications.
Thank you. I have no further questions on that clause.
Member for Johnson, clause 6.
Yeah, thank you. Thank you, Deputy Speaker. Minister, you said that the police would be wearing body cam when they were interviewing young people. Will legal representatives of the young person be provided with a transcript or recording of that interview?
If they request it.
Thank you.
Remember, it can't be admissible in court.
Understood, but yeah, I understand that. Thank you. Thank you, Minister. I'm not sure whether the member for Gotcha asked this question, but in terms of a serious and urgent matter concerning public safety, a very broad threshold, how is public safety specifically defined in this context?
It'll be done by the police on operational and case by case.
Thank you. And I think, as asked by the member for Gwadja, there's no requirement for a support person or legal representative to be present during an urgent protected interview, and an urgent protected interview is done whether there is an undefined serious and urgent matter. Is that correct?
Yes.
And the police have discretion to decide that?
Yeah, it's got to be imminent. It's got to happen on the spot. As I mentioned, this section is designed to stop the commission of an offence, to stop young offenders hurting themselves or their friend, and to stop hurting other members of the community.
Thank you, Minister. Under clause 6, section 17B, why is the young person not provided with a written notice after the urgent interview?
Sorry, what was that question? I missed it.
Oh, thanks, Minister. Sorry. Under clause 6, new section 17B, sorry, why is the young person not provided with a written notice after the urgent interview?
Because the interview can't be used against him in court.
So they're not provided with a notice because it's not admissible to court?
Yeah.
So what records will be required to be kept from those interviews?
Or their body cam and their notes.
Thank you. I've got
No further
no further
questions.
questions at this point, I think.
Member for Mulca, clause 6.
Thank you, Chairperson. I am also concerned about the sections of this bill that allow children to be interviewed by police without any adults. There should be always be adults present, and in many cases there should also be an interpreter present if police want to talk to a child. Police should have a in-house interpreter employed within their teams to ensure that children know their rights and can communicate clearly with police. Yeah.
Thank you.
So I'm not sure, but I'll just explain what we're talking about 17B here, the urgent protected interview. Now this occurs when there's a serious and urgent matter concerning public safety. So there's a threshold to be done. And the officer may invite the youth to participate in the urgent protected interview and to obtain information about the offence, and any statement, confession, admission given in this urgent protected interview is not admissible in court. The officer must inform the youth of his right to silence. And when you talk about the right to silence, I think it's in section 149 where you talk about doing an interview. The police officer is going to make sure that the youth understands that. If you're going to you don't have to talk when you arrest an adult. You've got to give a statement to that person. This can be anyone, and it's the police got to make sure that they understand what they mean. It's got to be an informed interview. So that youth has got the right to remain silent. So that even if the interview's going, any time the youth can say, I've had enough, I don't want to talk, the interview stops immediately. So it's really up to the police training. They do it day in, day out. If they interview someone to take a statement, there's always a first paragraph that says, this is your own free will, this is by consent, you don't have to give a statement, but if you choose to, we will take that for you. And remember, in the adults, that information can be used against you in court. This information can't be. This is about allowing the youth to have the opportunity, if they want to, they do it voluntary, and the police must explain it to them so the police themselves understand that, or they believe that the young person understands what they've been told. And they can use all sorts of different methods to do that, so to speak. And I've seen many police statements, and they go into, some of them, the whole page at the beginning of the statement is reaffirming that you understand that you've got the right to remain silent. And I've seen statements where the police officers ask them to paraphrase it back. And they ask, and it says they can have a support person if they want to. So if they can have that support. So there's a lot of work done. And again, this is what the police do day in, day out, as part of their everyday. Every time they interview someone, they've got to give them you've got the right to remain silent speech. And then they have to make sure, based on their training, that that person understands that. Otherwise, the whole statement is thrown out in court. And I've argued that myself in court, and I've been lucky enough to get them thrown out sometimes, and sometimes they get put in. But the police officers, and I want to praise the police officers, they do a great job in making sure through their training that the person understands their rights, because they know someone like me would be in court saying, hey, you didn't do that, my client didn't understand, so the rest of the information now is not admissible. So they do a great job in that discussion. So I hope that answers your question. This is really about the police doing a job they do day in, day out. It can only be used when there's the urgent, I'll read those words again exactly, I'll get it right. A serious and urgent matter concerning public safety. So this is not just, we'll pull someone off the street and have a chat to them because we heard on a grapevine that something might be happening. This is where there's a serious and urgent matter concerning public safety. Does that answer your question?
Member for Johnson.
Thank you, Minister. Just following up from that question from the member for Mulca. And I understand from what you answered me before, so Parliament's giving police extra powers without clearly defining when those powers apply. That's left up to police discretion. This does remove safeguards for children. I've heard your rationale, but Minister, safeguards for children exist for a reason. They weren't created to make policing more difficult. They were created because children are different. Every parent understands why children need an adult beside them when they're questioned by the police. Every teacher knows that. Every psychologist knows that. Children are more likely to tell adults what they think they want adults to hear, even if it's made up. They're less likely to understand the consequences of what they say, especially when adults don't explain things properly. They're more likely to become frightened or confused in unfamiliar environments. And that's why the law traditionally recognises that children should have the support of a parent, guardian, or other responsible adult when dealing with police. It's not just about protecting legal rights, Minister. It's about protecting children from making decisions that they don't fully understand. It's about ensuring that any information obtained is reliable, and it's about fairness. Minister and members, I ask people to imagine that your 12-year-old receives a knock on the door from the police. Imagine they're taken away for questioning. Imagine they're interviewed alone because police have determined the matter is serious and urgent. Imagine you don't know where your child is. Imagine your child is frightened. Imagine they don't understand what's happening. And I suspect every person, every parent in the Northern Territory would find that deeply worrying. The question before us is absolutely not whether police should investigate serious crime. Of course they should. The question is not whether young people should face consequences for their behaviour. Of course they should. The question is whether removing safeguards for children will cause harm to vulnerable children and put them at risk. And it's clear to me that removing the need for a guardian or lawyer to be present when children are questioned by police, as this bill does, will cause harm. And I just want to address what you've said in that nothing that's said in these interviews will be admissible, but that doesn't mean that information that is gathered as part of that interview will not potentially be used against other people, will potentially be harmful to the child. And those issues have been raised with me by legal representatives and things about how this information might be used in ways that are harmful to the child when they may not be aware of what the impact of it's going to be.
Thank you, Member for Johnson. Any further questions on Clause 6? No. The question is that Clause 6 stand as printed. Those of that opinion say aye, the contrary no.
Aye.
I think the ayes have it. The question is that Clause 7 stand as printed. Member for Johnson, did you have a question on that?
No question?
No question?
I think it's been answered.
Okay, been answered. Question is that Clause 7 stand as printed. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. The question is that Clause 8 stand as printed.
No.
Member for Gwadja.
Thank you, Mr Deputy Speaker. Minister, under the existing legislation, children can be held in custody for up to 24 hours. What evidence, Minister, supports the need to increase that limit to 48 hours when children are held in watch houses?
What the need is, Member for Gordon, is that the Territory is a big place. There are unforeseen circumstances such as storms and cyclones, crimes that are committed at different locations at different hours. This is about making sure that the police can keep the young offender safe, keep the community safe, and transfer them to that within 48 hours. And it doesn't have to hold them for 48 hours. If they can get there quicker, they can. Of course, this is just about doing that on an urgent basis to make sure that the young offender is safe, the community is safe, and they get them to, for example, the recent floods in Katherine. There were still crimes committed and the roads were shut. The airports were flooded in. So this allows for those circumstances. Again, I do stress it, not just if you get locked up, you're there for 48 hours no matter what. The police, who do an amazing job, will get you to the correct location as soon as possible, but it just allows for those weather events, the distances that we have here in the Northern Territory.
Minister, how many instances in the 2025-26 financial year did children exceed the 24-hour limit in police watch house cells?
It's not relevant to the operation of the clause.
I think it is. I'm asking you to perform a basis of why you're extending to 48 hours because you've just given me excuses for external factors.
I've answered the question.
So you're free to answer. Okay. Minister, what safeguards are in place to prevent 25A subsection 2, the 48-hour period, from becoming routine practice rather than a maximum limit only to meet in cases where other options cannot be considered to transfer a child?
Sorry, I missed that question.
Pardon?
I missed that question. Can you repeat?
What safeguards, Minister, are in place to prevent 25A subsection 2, that's the 48-hour period, from becoming routine practice?
The power is limited by statutory conditions, time constraints, and is intended only for situations where the immediate transfer is not reasonably practical.
Thank you. So, Minister, holding children in police watch houses for extended periods of time is widely accepted to increase the risk of harm or re-traumatisation. What provisions will police implement to ensure children are kept safe while in custody, essentially in circumstances where children are held in close proximity to adults?
There will be a custody nurse assessment to be done. Again, it is 48 hours, but clear to the intake, so they'll be moving out as quick as possible, but there will be all the police safeguards that they have in relation to watch houses now will apply. And I know that your government put people in there for extended periods of time, and I agree with what you're saying. If you're there for months and months and months, which is what Labor did, is not good. But what we're doing is we're making sure that we can get these young offenders into a watch house safe, into a intake or detention centre as soon as possible, based on the territory's distance, weather events, and those sorts of things.
So I guess, Minister, what I'm asking to understand is what provisions will be put in place when, for instance, it's a weekend, it's heightened, there's a lot of activity, the watch house is in a state of overwhelming capacity. What provisions are put in place to keep the child away from adults?
That'll be an operational issue to do with the police, right. And I think the police do a great job.
No one's disputing that the police, of course the police do a good job. I'm also interested in what additional services, given that you've got young people in, could be over a weekend, around additional provisions of support services that otherwise normally wouldn't be entering the watch house.
Again, that's a question to the police. It's an operational matter.
I don't have any further questions on Clause 8. I don't know.
Any further questions, Clause 8? Member for Mulca.
Thank you, Mr. Chairperson. Again, I feel deeply disappointed that we are seeing legislation introduced that is now a consultation with the community and now a referral to the scrutiny committee either. This bill does many things, but the sections that I am most concerned by the ability to hold children in watch house, which should never happen. Rather, no child should be held in a watch house. They should not be kept with adults who are unknown to them, and they should not be held in solitary confinement. Both of these situations are unsafe for children. Yesterday, the government wanted to talk about child safety, but they don't seem to understand what is a safe child or children. what are safe for children. I watch a watch house is not safe for children. I visited the watch houses and I saw and what I saw was horrifying for crown for ground adults, and we should never uh, subject. Say that again. Sorry. Horrifying for ground adults, and should never subject anyone, especially our children, in that environment for any month of time, or any amount of time, rather. Sorry. Thank you. Mr. Chair.
Thank you, Member from
Was that a question or just?
I think it was commentary.
Okay. What I'd say, my response to that is, the government aren't just going picking up children, putting them in watch houses. These children are committing a crime, the police investigate it, and they get charged. So it's a balancing act, and I fully accept that. But the bottom line is, this is not just random kids getting put in watch house. These kids are committing a crime. They're hurting themselves, hurting people, hurting the community, keeping the community unsafe, and that's what the police do, and that's what the government's role is, to keep the community safe. And we make no apologies. That's our role. We went to the election on that, and that's our number one priority, is to keep the community safe, so we make no apologies.
Thank you. Member for Johnson.
Thank you, Deputy Speaker. Thank you, Minister. Minister, will specific standard operating procedures be developed for this temporary detention? And will there be protocol for notifying an Aboriginal organisation when an Aboriginal child is held in these circumstances?
Well, the first part of the question is it's an operational matter, and the second part, that already happens.
So under this new that will continue?
Yep.
Yeah, thank you. I want to just follow on from the member from Malka as well, just to say this is absolutely, and as you said, this is not an argument against consequences of crime and keeping the community safe, but watch houses are not youth detention centres. They are not appropriate for young people. We've heard about what's going on in watch houses. We've heard from the Northern Territory Ombudsman. She didn't mince words when she concluded that no prisoner, regardless of the offence they'd alleged to have committed, should be held in the conditions that we were seeing in watch houses earlier. So if those conditions are unacceptable for adults, how can they possibly be acceptable for children for an extended period of time?
Talk to your Labor friends about that. They held them in watch houses for months.
I'm here to talk about what we're doing in the future, not what's happened in the past, Minister.
Sorry, point of order. Can we just let the member for Johnson continue her commentary?
Thank you, Chair. I'm here because I'm committed to community safety, despite what other people in this Parliament might say. I note the scoffing from the member. And I don't believe that we build community safety by locking up more and more children. I believe we build it by stopping children offending in the first place. That's what this government will be doing if it was actually really cared about community safety and not just headlines.
Thank you. Are there any further questions, Clause 8? No further questions. The question is that Clause 8 stand as printed. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. The question is that Clause 9 stand as printed. No.
Aye.
Member for Gwadja.
Thank you, Mr Deputy Speaker. Minister, currently Section 154 provides correction staff the power to use force when preventing a risk of escape. The proposed amendment seeks to amend powers to include the use of force when preventing a risk of an attempted escape. Can you provide examples of what the difference is?
So the attempting to escape is when they're still inside, but they're maybe running to the fence to jump over the fence.
Okay, so Minister, can you just, I guess I'm wanting to understand how correction staff are going to measure the risk. I mean, you've given me an example of someone running towards a fence, but it is also how do you make the determination? Is it behavioural that you then think that that poses a risk?
It'll be a case by case.
A case by case around assessing the attempted risk.
Yeah, it'll be case by case, but it'll also be behavioural and also intelligence gathered by the staff in that facility.
And then, so there's not a framework or a threshold around what would then constitute.
No.
Okay.
It's a case by case, depending if someone's trying to escape, and that'll be assessed by the officers who are trained to do their job.
So to confirm, Minister, thank you, the inclusion of preventing risk of an attempted escape will allow staff to use force on a child if they suspect the child might attempt to escape. So I'm just asking, could this behaviour include going, to the bathroom multiple times, displaying anxiety? I haven't finished yet.
Word might. You're
Excuse
putting
me.
words in
Yeah,
the
I'm still going. So the point is you need to stop while I'm speaking.
It says the word not might, it says or.
Minister, please, let the member for Gwadja just restate his question.
Thank you, Mr Deputy Speaker. As I was saying, Minister, I just want to confirm the inclusion of preventing risk of an attempted escape will now allow staff to use force on a child if they suspect the child might attempt to escape. Could this behaviour include going to the bathroom multiple times, displaying anxiety or discussing topics which could reference getting out?
The answer is no.
No? Minister, could you repeat? Was that no?
No.
No, thank you. So, Minister, why were there no limits or safeguards included to restrict this amendment, expanding the use of force in attempted escape to places outside the detention centre environment?
It's based on a case by case.
And what mechanisms are the department implementing to adequately report on the use of force around circumstances where they may prevent an attempt to escape?
They'll use the existing procedures.
Okay, so just to confirm those existing procedures, it'll be captured in the use of force register?
Yes.
Okay, and it'll be monitored and evaluated as it currently is?
That's not relevant to the clause, but yes.
Thank you. And what additional training will staff receive on the use of force relevant to this amendment?
We already do that. They already use
So existing? Thank you. I've got no further questions on clause 9.
No further questions. Clause 9. The question is that clause 9 stand as printed. Those that are printed say aye, to the contrary no.
Aye.
I think the ayes have it. The question is that clause 10 stand as
No.
printed. Member for Gwadja.
Thank you, Mr Deputy Speaker. Minister, what evidence gave rise to these particular amendments?
So there's numerous examples of young offenders returning to the detention centre after going out on visits and family visits with items that contraband has been brought back.
Okay. So, Minister, I'm just trying to understand, do you have a number of instances that you've been able to file to capture how many, pat-down searches had occurred during this time that found contraband?
It's not relevant to the clause.
So who was consulted on these amendments?
Correctional officers and youth justice staff.
Thank you. Minister, what safeguards will be put in place to ensure that searches of a young person or child are only conducted when reasonable, necessary and proportionate?
The current procedures that are in place.
The current procedures remain, thank you. And what mechanisms are in place to report searches for independent oversight? Is there a search register?
It's not relevant to the clause.
Okay, so we're talking about searches. I'm asking you, is there a search register around oversight to make sure that you're not just searching everybody, there's an accurate record?
I've answered the question.
Okay, well, how will the information be recorded and shared for monitoring and evaluation purposes?
In our client management.
Pardon, what was that?
In the client management system.
Client management system. Thank you. And are there any particular training that staff will be required to undergo in relation to these proposed amendments on how to carry out a search of this type and search safety?
They already train, but there will be an update to the training program they use.
Okay, thank you. I have no further questions on clause 10.
Member for Johnson.
Thank you, Chair. Thank you, Minister. Will searches be carried out by a corrections officer of the same gender as a child?
Where possible, yes.
Sorry, where possible?
Where possible, yes.
So it may be that a male officer will be searching a female child?
No, preference will be to return them to the centre.
Okay. Does that mean that a male officer will never be performing these now new pat-down searches with a child?
Well, you can never say never in this world, but that's certainly not how the procedure is.
Does that include for a trans child, will they be searched by someone who is the gender that they identify with?
Where possible.
Thank you. Can you clarify exactly what ordinary items could be captured under the definition of prohibited thing? Could it be a spoon? Could it be Play-Doh?
Could be scissors, makeshift weapons, and sharp objects, those types of things.
Okay. So could a spoon be included?
No.
Thank you, Minister. I think just while I'm on my feet, this is something that people have raised concerns with me about, blurring the distinction between a pat-down search and a more intrusive personal search, expanding what can occur during a pat-down. A search that I now understand allows an officer to search over and under a child's waistband is no longer what most people would understand as a routine pat-down. Is that correct, Minister? Does this search enable people to search over and under a child's waistband into their underpants?
No.
It doesn't? So what are the boundaries of the search?
The top of the waistband.
Top, so not under the waistband. Okay, thank you. Thanks for clarifying. Thank you. No further questions.
No further questions? Question is that clause 10 stand as printed. Those that opinion say aye, to the contrary no.
Aye.
I think the ayes have it. Question is that clause 11 stand as printed.
Aye.
Those that opinion say aye, to the contrary no. The ayes have it. Question is that clause 12 stand as printed.
No.
Member for Johnson.
Thank you, Chair. Thank you, Minister. New section 168C states that these new facilities are to temporarily hold detainees. How is temporarily defined?
As soon as we're able to remove, and it's the ordinary meaning of temporary. You can.
Thank you, Minister. Can you help me here understand what is the ordinary meaning of temporary? Is it an hour, a day, a week?
Case by case, but it's just the court will look at it, what the how they view it if someone wants to take it to court, but the court will use the construction and they sometimes refer to the dictionary.
Is there any strict statutory limit on the amount of time a young person can be held in an intake and transfer facility?
No.
Thank you. Is there a requirement to notify the young person's family, legal representative or support person before a transfer occurs?
Where possible.
What would make it, can you expand that? Where possible means?
If the parents are available, if the parents aren't available or a support person not available, it won't happen, but certainly all steps will be taken by the department to contact them, but it's simply they're not contactable, and that person, we have to weigh it up whether they stay in a temporary because you're trying to find someone or you put them back to a facility where they can have the wraparound services. Again, it's a balance, so that explains that.
Thank you. Clause 12, new section 168D outlines the responsibilities of the superintendent of an intake and transfer facility, but omits the duty which applies to detention centre superintendents to encourage the social development and improvement of the welfare of detainees. Why was this left off?
Because it's only a temporary facility.
But with a time frame that is, you can't tell how long that temporary may run for. Which provisions of the Act apply to these facilities in terms of official visitors? Are official visitors applied to intake and provisions, applied to intake and transfer facilities?
No.
Okay, so what independent oversight is there of these locations?
The Children's Commissioner.
Which we don't have.
Thank you.
Okay, no further questions. The question is that clause 12 stands printed. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Question is that clause 13 stands printed.
No.
Member for Gwadja.
Thank you, Mr Deputy Chair. Minister, what evidence has formed the basis for the inclusion of this amendment?
It's an administration process.
An administration process? Is that what you said?
Yes.
Yep. Thank you. Can you provide the circumstances when a police officer would be in the detention centre? Are they called to fill in when correction staff levels are not met?
Yeah. If there's an emergency event, such as a riot, police would enter.
Thank you. And how many instances have police been called to operate within the Holt's Youth Justice Centre in the last financial year?
That's not relevant, but I'll answer it. 0.
0. Thank you. Minister, how is the department ensuring that there is cultural safety of having police operate as pseudo-correctionist officers who will interact with vulnerable children?
It's not relevant to the clause.
Sure. And what safeguards and limits on police will be in place to reduce unintended conflation of powers?
That's not relevant to the clause.
No further questions.
No further questions. Question is that clause 13 stands printed. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Is it the wish of the Assembly that clauses 14 to 17 be considered together?
Aye.
There be no objection, it is so ordered. The question is that clauses 14 to 17 stand as printed. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. The question is that clause 18 stand as printed.
Aye.
Thank you. Just for clarification, Mr Deputy Speaker, those questions have been answered, so I'm happy to proceed right through.
On that basis, no further questions. Member for Mulca, clause 18.
Clause 18, thank you, Mr Deputy Chair. Chair, I am also concerned about the sections of this bill that create a significant jail time for young people in regard to assaulting a corrections officer. Corrections officers have the right to be safe in their workplace, and children have a right to be safe too. This is one of the clear reasons why we don't want our kids in detention. We want them on country, in the care of elders. Young people are still developing their knowledge and skills. They are not always making good, thoughtful decisions. Sometimes they have intellectual disabilities, and in some cases they suffer from fast D. If they lash out when they feel upset in many, it may not be thought through. They can be impulsive. Now, if this happens when they are detained, if they are upset and angry, and lash out, they could face many more years in detention. This bill creates a maximum of 16 extra years in detention. In this detention environment where they are not being cared for by their family, where where they are in an institution, and it is strangers who are their carers, who do not have love for these children. They may not care for the child is hurt or angry. They they may not care if the child needs love and care and some kind words. Corrections workers do not know the child, the way their kin and country knows them. They cannot care for the child the way their kin and country can care for them. If the children is with elders and they lash out, we can weather the storm rather. I and we know and love the children. We can reach them and love them and give them that they need to become a better people. This bill creates problems for these children if they lose their temper and lash out when they are frightened or upset. They may be undisciplined and still need to be taught self-discipline. And this is why we need to um, fund programs and on country and take kids onto country where they can learn discipline, respect, and pride in who they are. I have called for the community-led programs. We want refugee camps, we want peacekeepers and law and justice groups to be funded on country. As I said yesterday, come and work in partnership with us. And but again, today we get no support for our communities. Instead, we get new laws that are punitive and damaging for our children. Let me say this very clearly. Stop demonizing Aboriginal people and come and work with us that requires funding on country, not more funding for jails and more punitive laws. Thank you.
Thank you, Member for Mulca. No further questions. Question is that clause 18 stand as printed. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Question is that clause 19 stand as printed. No.
Aye.
No questions. Those that opinion say aye, the contrary no. So, I think the ayes have it. Is it the wish of the Assembly that the remainder of the bill be taken together? There being no objection, it is so ordered. Question is that the remainder of the bill stand as printed. Those that opinion say aye, the contrary no.
Aye.
I think the ayes have it. Question is that the bill be agreed to. Those of the opinion say aye, the contrary no. Aye. I think the ayes have it.